Great. All right. Again, want to thank everyone for joining us today. My name is Lindsey McKay, and I'm the lead advisor at McKay Wealth Management. And today we're going to talk about estate planning, specifically for Washington State. Laws vary state by state. So we're predominantly going to be talking about the state of Washington. If you have property or live outside of the state, know that different rules can apply, and we can happily give guidance around that if there are some specifics that you want to make sure you address. Will mention not an attorney, so the advice that we're giving today is just broad guidance, and we do have professionals that we partner with. So if you are in need of reviewing estate planning and or updating your current estate planning, we have professionals that we can connect you with. We ask that you just talk with us first. We can have kind of a preliminary conversation and make sure that we can connect you with the right individual, but just know that those resources are available to carry you across the finish line besides just giving you the guidance that we're going to go over today. All right, with that, I'm going to get into the meat of our presentation. So we're going to focus really on just some main questions that come up frequently with clients when it comes to estate planning. Obviously, it's hard to cover a lot of specifics because they vary so much from individual to individual. So this is a high level conversation that we're looking to get started. And then if this sparks questions for you, or if you have unique situations that you want to consider beyond, some of the generic or general stuff that we're going to go over today, again, encourage you to schedule a time for us to speak or bring it up in your annual review so that we can make sure that we're addressing some of your top concerns or things that are really the burning questions that you have beyond some of these common questions we're going to address. So the first question that we have here is, what is the current Washington State estate tax threshold? We saw it increase in 2025. For a long time, it was 2 million, and we saw it increase. It increased to 3 million and then had a slight adjustment for inflation. But what's happened this year is that we actually have a split year due to some recent legislation that changed the brackets. So while the overall exempt amount or the threshold, I guess, for where we see estate taxes apply hasn't shifted much. What you'll see on the chart here is that depending on if someone passed away in your family in the first 6 months of the year, there's going to be a different tax rate applied for amounts above the threshold than if they pass away after July 1st, at the second half of the year going forward. So it's probably looks a little bit more confusing than it needs to be. We'll talk a little bit about this first half of the year, but I think we really just want to focus on what's going to happen going forward. So what you'll see on this bar chart is the tax rates that apply once you exceed the exemption of 3 million, and then the tax rate that applies to the first million, the next million, so on and so forth. And so what you'll see is in the light blue bars here is what's going to apply to the first half of the year. So you're going to see higher taxes across the board once we get past that initial 1 million above the exemption. And then you see it going all the way up to 35%. Again, that's only going to apply to someone who passes away, who has assets above that $3,076,000 threshold for the first half of the year. If they pass away the second half of the year and beyond, the current tax laws are going to revert to those lower tax rates. So the dark blue line. So if we wanted to look at an example, we would say if someone had a $5 million estate, there wouldn't be taxes on the first 3 million. There would be a 10% tax on the next million. And then assuming they passed away in the future, past that July 1st date, there would be a 14% tax on that second tier or second million there. So you can see that there's a lot of taxes or a lot of assets that will pass without taxation, that $3 million amount. And then we start to see taxes above that start at 10% and gradually increase to a maximum of 20. And so I think a big positive is showing that the decrease in rates versus what those higher rates were in previous legislation. So the tax rate or the estate taxes kick in fairly quickly in Washington. If you own a home, some investments, you can easily creep up towards that 3 million. And one of the things we're going to talk about a lot today is how that's 3 million per individual. And if you're married, the steps to make sure you take in order to protect that for both of you. We're going to briefly talk about federal amounts and then we'll kind of hone back in on Washington state. So we currently have a relatively high federal exemption amount. It's 15 million per person, so 30 million for a couple. So most people are fall below that. And so we're not doing or seeing a lot of planning around these federal exemption amounts. But I do want to mention them because just like Washington State, those will change over time. They were previously 5 million per person, so 10 million per couple. So obviously we saw a big increase in the amount back in 2017. Um, and there is likely a point in the future where we will see that number drop. I'm not saying it'll drop down to, the previous levels that they were at, but just something we want to make sure that we pay attention to in our estate planning conversations is these tax laws that change over time. There's also an annual gift exclusion amount. So this is where you can give money every year to an individual or individuals and not have it count against your lifetime exemption. So a lot of times clients will say, you ask about giving, and they are asking because they're concerned that it's going to be taxable to the person they're giving to, or wondering if they get a tax benefit for giving. It's a tax neutral when we give this $19,000 amount. You don't have to disclose it. There is no issue of it adding up and coming out of that lifetime amount that you can give. So for people that are getting to the point where they say, I know that I'm going to have more money than I need in my life. I know that this money is going to go to my beneficiaries at some point. Should I start giving to them sooner rather than later? This is the amount that we start to talk about as a easy amount to be focusing on. It's per person. So like I said, if you're married, or you can give 38,000, or if the person you're giving to is married, you could give them 38,000. So we can add up quickly to be able to start giving a decent amount of money when we think about wanting to get money out of our estate. And as we're going to talk about today, a lot of that is much more on the Washington side than the federal side because the federal limit is currently so high. Marital deduction, you can, from the federal standpoint and the state, money that you gift to your spouse upon passing doesn't trigger any taxes. So that's not something we need to necessarily worry about at the first threshold, but we're going to talk about what we need to think about when that secondary person passes away. Charitable deductions, if you're giving to charity while living or at death, that's going to allow you to decrease the size of your estate. And then we aren't going to really focus on the federal estate taxes just because most people are going to fall below that $30 million threshold. But just know that the tax rates are higher with the top tax rate being 40% when you get above that exemption amount. So purpose for the conversations today are really to focus on Washington State, but if you are in excess or feel like you could be in excess of that 30 million, we want to make sure we're thinking about the federal taxes as well. So I mentioned quickly when we start thinking about taxable estates, one of the things that people will ask about frequently is this idea of a trust. And, should I use a trust in order to avoid estate taxes? And so I really just wanted to highlight here, there's a lot of information on that slide, but that trusts are not all created equally. And just because you have a trust does not mean that the trust or that the assets that are in the trust are going to be excluded from your estate. And so we'll talk a little bit more about trusts throughout this presentation, but it's really a matter of when we think about trust, what are we asking the trust to do? So we're going to talk later about, the trust is a vehicle that's going to ease the transfer of assets. That typically is going to be a revocable trust, which doesn't exclude it from your estate, but it'll allow you to accomplish a lot of other goals that you might have. Where if your primary objective is to make sure, or one of the primary objectives is to make sure that the assets are not included in your estate for tax purposes, that's going to be a situation where we need to have it be an irrevocable trust. And an irrevocable trust, again, can be a great vehicle for accomplishing a lot of objectives, but it also requires you to give up control of the assets. And so, a lot of times when people are coming and asking about trust considerations and, whether or not that's applicable to their circumstances, I think that for the most part, people are thinking about a revocable trust. And so, we just want to remind ourselves that while that can help accomplish a lot of goals that we might have, including simplifying our estate planning, it doesn't exclude it for tax purposes. So again, we just need to think about what is it that we're ultimately trying to achieve and then work backwards to decide if there are different types of vehicles that we can put into place that would allow us to achieve those goals. So more to come on trust conversation, but just wanted to kind of address that at the beginning because I think that's one that people kind of immediately jump to is should I have a trust in place? The next question that we have here is the Washington state estate tax exemption portable between spouses? And can be a little bit confusing because, as I said earlier, we can transfer our assets to our spouse without there being taxes. But what we can't transfer is that exemption amount that I referenced. So in Washington state, the 3 million that applies per person does not roll to your spouse. Meaning, if you had $5 million, you might be thinking, well, we're below that combined 6 million. So I'm just going to let the money transfer to my spouse. And when they pass away, they'll be below the 6 million. The challenge with that is that your 3 million has not transferred to them. So they now own $5 million of assets in this example, but their exemption is only 3 million. So we really want to make sure that if we are close to or believe in the future could exceed that $3 million threshold, we want to make sure we really protect both exemptions in a married couple situation. Now, if you're an individual, obviously you only have a $3 million exemption, and so that's a different scenario that we would need to work through with you and talk about planning opportunities in order to help minimize estate taxes at the Washington level. But when we have a married couple, we have 6 million to work with, and so we just want to make sure that we're really being thoughtful and intentional about how we can transfer as many assets as possible without triggering estate taxes. And so a way that we're able to do that is with preserving that exemption amount while still transferring assets to a spouse. So meaning we don't skip over the spouse and have the monies go to somewhere else, is we're able to use testamentary trusts. And those are trusts that are created by your will. And so that's very common to just have documentation in your will that says, upon my passing, I want there to be a trust created that will protect or preserve my exemption amount while still allowing my spouse to have access to the access to the income. It can also help provide for minor children or special needs beneficiaries, and it can also set parameters for when distributions can occur. So there's a couple of different objectives that these can help achieve. We're primarily talking about preserving that estate tax exemption, but just listing some other places where this can be of good value. So it can be where we're trying to protect that exemption amount, but we're also have a blended family, and so we want to provide for one of our spouses or for our spouse who's from a second marriage, but we also want to make sure that we can control the ultimate beneficiaries. We can also set up these types of trusts to say, I have children who are underage, so we need to make sure that the monies are set aside for them until they reach a certain age, or we can have them be to take care of beneficiaries who have special needs. That's a whole different type of planning to allow them to still qualify for state and federal benefits that would be available to them. We can also just have, sometimes we have beneficiaries that giving money to them is gonna create more problems than it'll help. And so having some trust there can that trigger upon our passing can be helpful to just protect them from themselves. And then I did note on here that these types of trusts, so trusts that are created by your will, do not avoid probate. So earlier I mentioned where we're trying to get, um, we can use trust so that it's the ease of transferring assets. Those types of trusts have to be created prior to passing away and assets moved into them. So we'll talk about that a little bit later. These types of trusts are trusts that trigger upon one's passing. And so common ones that are used to, continue to protect the exemption while providing for a spouse. These are common trusts that you may have heard of: a marital trust, also known as a trustee; a bypass trust, which is known as a B trust; or credit shelter trust might be an exemption that you've seen. And then a Q-tip or a qualified terminal interest trust. Those are ones where that can help control the ultimate beneficiaries. So again, some of these are meant to strictly for estate tax exemption or tax planning. Some of them are meant to help control ultimate beneficiaries, and others are just saying, I need to provide income for my spouse. So it's but want to make sure the assets are trust owned, and so it could be a combination of these. And trusts start to get a little complex when we start to think about these different kinds. And so, again, our objective for today is to just educate you on some common types that are out there, some things that you might have seen or heard. Potentially, you may have them in your own documents. But I think most importantly is if we are mentioning something that you think could be applicable to you that you do not have in place, that's where we want you to pause and say, potentially, an opportunity to revisit my estate planning and think about what I currently have in place, and if there's things that I might be missing or need to think about adding. How do I start to better understand what those pieces could look like? And so we're going to talk a little bit later about how often you should be revisiting your estate planning, and when it makes sense to do a revisit. But I think one of the things that causes a lot of people to be revisiting their estate planning right now is just that their assets have grown so much, a lot of it driven by the value of their home. And so if you haven't looked at your estate planning in a handful of years and your net worth has grown tremendously, probably a good time to be revisiting and at least having the conversation with us so that we can better understand what your current planning in place is, and then give some guidance as to if it needs to be revisited or revamped based off of change in assets, change in circumstances, etc. All right, we're going to move on to question number 3. How does Washington's status as a community property state affect my estate plan? So there's a lot of things to understand around this, and for most people, they just sort of assume that basic example I gave earlier, where I pass away and all of my assets automatically flow to my spouse because we live in a community property state, which means that by law, everything is considered to be owned 50-50 unless it has been documented to be otherwise. So we'll talk about that in a minute, but the answer to that is true, where if you are to pass away and didn't have a will in place, it doesn't matter about anything else. All of your assets would pass to your spouse. So that can be a real positive benefit as far as the ease of transferring assets, but we also want to make sure that we're considering that combined asset level. And if we need to do some planning so that we don't automatically have that 50/50 or that, 50% of my assets are owned by my, automatically roll to my spouse. The other thing that is beneficial about this community property state is the way that assets are revalued when someone passes away. And so there's a lot of assets that we own where they get a step up in basis, which means they get revalued at the time of death, and the basis or what we originally invested in it is reset to its current market value. And so these are things that, like a home that you own, um, investments that are owned outside of retirement accounts, anything that falls into that, I would be paying capital gains on it. If I sold it and there was a difference between what I purchased it for and what it's currently worth, that essentially gets stepped up to its full market value upon the passing of one of the two people um, in a community property situation. So it's called a double step up and is really beneficial as far as enabling the surviving spouse to eliminate a lot of taxes that maybe have ballooned or grown during the lifetime that those assets have been owned. It can be a great planning tool, but I think we want to make sure that we're using that in a big picture situation where we're also thinking about, the long-term size of our estate. So back to that thought of we don't necessarily just want to have everything roll over to our spouse for outright ownership. Are there other considerations that we need to be taking where we can still benefit from the step up in value? So I mentioned in Washington State, everything's going to default to be a community property state unless you've declared otherwise. So there are instances where you want to be mindful of, do we want everything to be jointly owned in that way? So titling can be really important. There's also things where do we need to take extra steps in order to factor in assets that were owned prior to marriage, and how do we want to treat those? And so, just knowing that this isn't necessarily um, an estate planning tool in and of itself, living in a community property state is the point that I think I want to make there. And if you have questions around assets that you feel like would not be designated as community property, that's something else that we would want to address and think about from your estate planning standpoint. There's been lots of talk about all the taxes that Washington State has, including a capital gains tax. And so, for those of you that are not aware, Washington State doesn't have a personal income tax, but it does impose a long-term capital gain tax on certain assets that are sold above an annual exemption amount. This is one where people try to understand how is this going to impact assets that I transfer when I pass away. And so, because of that step up example that we gave earlier, that when you pass away, the value of your asset is reset with current market values for things outside of retirement accounts or annuities that have a different tax structure. We don't see a lot of capital gains applying to inherited properties. So, what happens is whether or not your spouse is inheriting it or you're passing it to your children, assets that get that step up in value, like a home or an after-tax investment account, that resets the value as of the day of your passing. So gains are really going to only apply to any change in value between the time that it is revalued from your date of death to when whoever inherits it ultimately decides to sell it. And so we can see gains that occur during those time periods, and hopefully we do see gains that occur during that time period. But what we've eliminated is essentially I bought this stock 20 years ago, or I've owned my house for 30 years, and there's been a tremendous amount of appreciation that has occurred. That appreciation is going to be eliminated by that step up in basis. Now, I will say that there is a process that you need to go through in order to make sure that assets are valued as of the date of death. This is particularly important on real estate when an individual who's married is the first to pass away. You need to make sure you go through the process of getting a valuation of that property at that time in order to make sure we get that step up. Investments or other things, are typically handled when the investment firm is making those changes. But the good news is for this question in particular, the answer is that capital gains are really going to be minimal. And the places where we really see taxes come into play are the estate taxes, which we already talked about, above the $3 million threshold, and then tax deferred assets. So those are retirement accounts or annuities, places where taxes have never been paid, and there's been a lot of appreciation that has been occurring over time. And those don't have capital gains, they have ordinary income tax. So that's another consideration when we're setting up estate planning of the how are those taxes being paid? And if we want to have them paid by an individual versus a trust, so retirement dollars, for instance, a lot of times we'll see those default where they're going to go directly to an individual who has the option to distribute them over a 10-year time period, as opposed to going directly to the estate or a trust where it could trigger a one-time taxation. So, when we think about taxes in the estate planning sphere, it's not just that over $3 million threshold that we are thinking about and planning for. It's any assets that have tax deferral in them. We also want to make sure that we're considering the tax implications that those will have for the individuals that are inheriting them. Question number 5, is probate expensive and should I use a living trust to avoid it? So we talked a little bit earlier about this ease of transfer, and I think that's primarily when we think of probate, people think of it as a cumbersome, lengthy, expensive period of time where you have to go through the courts in order to execute on a will. And what I will say is that, again, this varies from state to state. So in states like California, New York, I think that there's a lot higher cost and a lot more challenging process to get through probate. Probate in Washington isn't necessarily a complicated situation, but it is a process that you have to go to in order to get the assets into your estate. So that's really what probate is. Probate is you have a will, the court's gonna review that and say, okay, great, you've appointed this individual to represent you in distributing your assets. We're gonna need to give them legal documentation in order to do that. The person that you've listed as your representative then uses that documentation in order to, get all of the assets that you own titled into your estate. And then from there, distribute those based off of the instructions in your will. And so it's not necessarily, a process that should be avoided in a lot of instances. It's actually the best process to go through for what you ultimately want to achieve. But I think there's some kind of misnomers about the fact that it's you want to avoid it at all costs. I wouldn't say that that's necessarily true, but I do think that if your goals are to transfer assets as seamlessly as possible, then that's where we want to think about, okay, are there ways that I can streamline this to help alleviate some of these added steps that might be needed? So earlier we talked a little bit about trusts and the idea of using a trust to help with our estate planning. And there's different types of trusts. And so we've highlighted earlier that an irrevocable trust removes the asset from our estates. So that's more of a tax planning or, a long-term strategy where a revocable living trust is one that just says, hey, I'm going to have this asset owned as a trust. I'm going to have a trust document that gives guidance on how it needs to be managed by the trustee, the person that's responsible for it. It's also going to list who the beneficiary is, and it's just going to allow me to have ease of control over my own assets while I'm living. There can also be stipulations where I add in if I'm not able to make decisions on my own, there's a successor trustee that can step in and handle it for me. But it's really just going to say it's a seamless process of when I pass away, that legal document in the trust dictates who takes over the money and who the beneficiary is and how it's meant to be handled. So it sort of operates similar to a will, except that it only applies to what is owned by the trust. So that means that you have to retitle things to be trust owned. We a lot of times will come across people that say, I have a trust. And then we'll ask a few more questions. We'll dig in a little bit more, and they'll say, well, I don't like the trust doesn't own anything. So in that instance, this type of trust isn't providing any benefit. So we want to again identify what's our primary goal, and then would a trust help us achieve that? So that's the secondary question. And the third question would be, does that trust need to be created now, or could it be created upon my death, which are some testamentary trusts that we talked about earlier. So trusts are great vehicles. There's a definitely good use cases for them. I think the problem is that a lot of times people just feel like they should have a trust, but they're not sure what kind of trust and what that trust should look like. And so it kind of gets stalled. And so when we're helping clients think about their estate planning objectives before they meet with an estate planning attorney, we're starting at the what do we ultimately want to accomplish and then sort of working backwards to see at what point would a trust become beneficial, or are there other ways that we can accomplish similar objectives and where we wouldn't necessarily even need to have a trust in there, or the trust could trigger upon their death. So we see a lot of revocable living trusts for assets that are held outside of retirement accounts. You can work to retitle for your home to be in there. There's definitely a place where this can be a great tool, primarily for a lot of the things that we're talking about. It's the ease of transfer of assets. It doesn't avoid probate, which is one of the things that I think a lot of people thought that it could or would, but that's not necessarily the case. But as I mentioned a few slides ago, 2 slides ago, that I don't know that we need to be fearful or concerned about the probate process. So it's really again, what are your unique estate planning goals? What's your family dynamics? How can you utilize some of these different pieces in order to make it be efficient, but also not complicated? That's the other thing we've done a lot of work with clients where we go through estate planning that exists and realize that it's just they overcomplicated it. So in a lot of ways, we want to just simplify the process as much as possible. And so, looking at the full financial picture, what kind of assets you own can be helpful in doing that. For example, retirement accounts have beneficiaries, annuities have beneficiaries, even after-tax investment accounts can have beneficiaries. So, if our goal is to ease of transfer for assets like that, and it's clean where we're transferring it to one or two or three children, we could just use beneficiary designations to accomplish the same thing that the trust might. But it alleviates a step and makes it, a little bit more efficient As far as each individual who's inheriting the money, we can work with them directly as opposed to having there be a singular trustee and working with that trustee to transfer assets. So that's just an example of how we can help look at the picture for you and say, I think we could accomplish a lot of your objectives using this strategy. Or, it's complex enough that maybe we need to think about adding in some additional trusts or layers that could really help achieve those additional goals or complex solutions that we need to figure out for you. All right, we're going to get into some bonus question here. How often do I need to review my estate planning and associated documents? This one I feel like people ask all the time, and it's one of those ones where a lot of times we set it and forget it. But I think that it's good to revisit every handful of years. So, 3 years, maybe 5 years max, to have a conversation with us. That doesn't mean that you need to have a conversation with the attorney, doesn't mean that you have to necessarily redo your documents. But a lot of times, what we're finding is if planning was done too long ago, a lot has changed in your circumstances, and a lot has changed in the laws, and so that can really change what makes sense from a estate planning document standpoint. So we want to always just kind of be checking in on it and saying, hey, has your objectives changed? Has your financial situation changed? Has your family dynamics changed? I mean, there's a lot of moving parts to all of this. And so I think it's good to just revisit every few years to make sure that it's still going to accomplish what you want it to. And it's really important for us to know if you have made changes or want to make changes because a lot of the work that we do on our side, I mentioned retirement accounts, annuities, even investment accounts, where we have beneficiaries in place, those beneficiaries override anything that's listed in your will. So you could have changed your will to include additional family members or charity or things that are not reflected in your beneficiaries. And unfortunately, those changes in your will could not be fully implemented because there's not enough money that's going to flow through the estate side with the way that we had the beneficiary set up. So we've been seeing lots of changes and lots of adjustments that we've been helping clients look at and make. And so I just, want to really reiterate that we need to make sure the work we're doing on your investment accounts supports what's documented in your will and doesn't negate any of the updates or wishes that you may have there. So we talked a little bit about, when we think about this estate planning documents and the tools that you have, I've talked a little bit about account titles and beneficiaries. These are really important. Account titles, we talked about Washington State being a community property state. And so we need to make sure that we want it to be that joint tenants with right of survivorship is the default in our state, which means we own it together. If we're living, it's 50-50. If we die, the other person gets 100%. That might not be the case for estate planning purposes. We might want to say we own it 50-50, and if I die, my 50% needs to be how it handled is needs to be determined by my will, not automatically defaulted by the title of the account. Same thing with the beneficiaries. I already touched on that. There's a lot of different ways that we can title accounts and update beneficiaries, so it's good to revisit. Um, Account titles can also include adding beneficiaries. So you may have seen TOD or POD. That means transfer on death or payable on death. That's where you can have an account where it typically doesn't have beneficiaries, but you can add them to it with proper titling. Um, Asset transfer documents. So we talked to already, like things that don't automatically have beneficiaries tied to them are going to be transferred based off of the instructions that you have in your will, or if it's trust owned, then what does the trust document say? Beyond all of these things, we also have um, documents that help us decide when we're unable to make decisions for ourselves because of incapacity. We have powers of attorney that can help for financial and healthcare instructions. We also can have healthcare directives where we can say, hey, I want to have written instructions of how I want, my healthcare to be handled if I'm unable to do it on myself. So even though we may appoint someone to make those decisions, we also want to give them guidance on how to do that. So these are ones where these also change over time. We've had a lot of people who maybe 15, 20 years ago, it made sense to have a close friend be your representative or your power of attorney, but you're not that close with that friend anymore. Or a lot of times I have people say, well, that person's, aging just as much as I am. I probably need to find someone who's younger to list. Those are the sort of things that could also warrant an update outside of changes in your circumstances. It could just be that we need to revisit who we've listed to be responsible for, for those decisions for us. So, without a will, the state does decide what happens to your assets. So, in a community property state, it is relatively straightforward as far as passing to your spouse if you're married. And then there is sort of a lineage that goes through for, children, parents, siblings, all of that stuff. So, it's not necessarily that the money wouldn't go to someone you don't want it to, but it's also just a much lengthier process. Guardianship for minor children is important if you're in a situation where that could be applicable. And then I think the biggest thing and the whole point of, today's conversation is really around this. How do we maximize the value of your assets by considering the estate planning side? And so that means not only minimizing taxes, but that could also be maximizing who is the money going to. And that's for family members, that can be, does it go to my children or my grandchildren? Are there challenges if it's going to my grandchildren and they're minors? Should charity be included? I'm charitably inclined. How does that get accounted for? So it really is beneficial to just take the time to slow down and think through some of these, what happens when someday we pass away. I know it's hard for us to want to sit in that and think about it, but it is something that will happen to all of us at some point. And so when we do our planning, it is helpful to think about a shorter time period. So, what would happen if I passed away in the next 5 years? If I'm reviewing it every 5 years, I don't need to make decisions for something that is 20 years down the road when I don't know what it's going to look like or I'm not sure what the circumstances are going to be. If I'm reviewing it regularly, I can make decisions today for what I feel like will look like 5 years from now, or some period that's relatively short in the future. That's another benefit of reviewing it frequently, is that it's a lot clearer when we try and see or picture what circumstances would be like a handful of years versus decades down the road. I mentioned the importance of some of these other documents. If you don't have them in place, I do think it is important to think about who's going to help to make decisions for you while you're living if you're unable to make them for yourself. I think that this comes up more often than we sometimes think. And it's challenging to not have this in place and scramble to get it in place. So I do encourage you to think about, from our perspective, we're mostly dealing with the financial side. Is there a family member that it would make sense to be your decision maker around the finances? We also will see it happen on the healthcare side. And on that side, it's important to make sure that we've kind of clearly communicated what some of those wishes might be. I also will say that these do not have to be one and the same. So we have a lot of people who have, family members where they don't want to exclude someone, so they list everyone for all of these, or they just think it's going to be burdensome for one or the other. But it's important to stop and think about who would be the best person to have this responsibility for you. It is a responsibility, and we want it to be something that they feel that they can manage and that you've given them enough instruction to understand what your wishes would be and how you would want them to be handled. So a lot of times, reviewing these and updating them, it's then helpful to communicate to the people that you've listed, one, why that you listed them and what your wishes might be. And then two, for other family members, if you're not including them, let's just say you have two children, you've decided one's going to be in charge of medical and health and one's going to be in charge of finance. I think that that's fine to just communicate that, hey, we've listed you to do our health and your sibling to do our finances because, those are the spots where we feel like, you both live in those areas and are able to, provide us with the help and guidance that we'll need without it being stressful to you. As opposed to saying, let's just put everyone on it and then they have to decide together on these. That can make it a little bit complicated. So we've seen it where, like I've said, don't be hesitant to just say, you know what, we think you'd be better at the healthcare side, and someone else is going to be better at the financial side, and we're just trying to make it easy on you, as opposed to just saying, well, we'll just let you guys figure it out when the time comes, because that can end up being stressful for everyone. So, like I said, this was a quick run through of just some things to get you thinking about estate planning. There's lots of complexities and considerations to think about, especially as your circumstances shift or change. I will say that we've had a lot of opportunities to review these with clients, and um, there's usually some really positive takeaways from the discussions, either confirming that everything is in place as they want it to be, or that they've identified some areas where they need to revisit. And one of the things that we're really good about is helping to ensure that you do revisit it. So there's some accountability that we can help you with to just say, like, we need to get an appointment scheduled with an attorney. We can give you the referral to the attorney. And then, we're going to want to follow up and make sure that the next time we meet that you've had that conversation and are getting the process rolling as far as getting your documentation reviewed and updated. And I mentioned earlier that it's not always that it needs to be completely redone. If you've done planning relatively recently and it's just minor updates, it could be something where you're just adding a page or two with additional instructions. But even if we are having to redo estate planning, it's relatively cost effective if you're doing straightforward, non-complex planning, so it's not overly expensive. So I just want to make sure that people don't feel like it's the cost is a deterrent of getting it reviewed or updated. I think that it's money well spent in order to make sure that your financial affairs are in order for end of life or unexpected changes in your circumstances, um, which, as I said, we unfortunately do see from time to time. We do have, we left about 10 minutes left at the end here. If there was any questions that pertain to the group as a whole, I know when we talk about this, it tends to be more specific questions to your unique circumstances. So if you do have a question or a concern around your planning and want to address it, please reach out and schedule a time for us to do so. If you don't have estate planning completed and know that you need it and want to bypass us and go straight to an attorney, reach out and get that referral as well. But just know that there's lots of resources out there to help get you to where you want to be. And I think the easiest or the hardest part for you, but the easiest part for us is just get the conversation started. So don't hesitate for us to be the first place that you check in and get that clarity around what do we ultimately want to achieve. That's the role we can help play, to just say, let's figure out what you ultimately want, and then we can sort of create a path for what that could look like and walk through some of those scenarios so that by the time that you talk to an attorney, you feel like you're armed with enough information, and clarity around what you ultimately want to achieve, that you don't have to spend a lot of time working through it with the attorney. So with that, we'll go ahead and end the webinar for today. I want to thank you again for joining and look forward to talking with all of you about your estate planning next time we chat. Have a wonderful day. Bye.